Hi all, welcome to our webinar this morning on data subject rights and employment issues. So you've got myself and Gemma Chubb, a director in our employment team, but I think the initial invite was somebody else, but actually today you've got me, a trainee in our Silicon Valley team, on secondment from our London office. And I sort of paralegaled in privacy before, so not completely new to the topic, but I've only been here for a couple of months. For those of you who have been listening to our webinars before, this one is a slightly different format. Rather than to talk you through sort of data subject rights and what they are and how you deal with them, we've sort of taken a case study approach. So we'll take you through sort of some example letters and the key things to look out for and how we would approach responding to those. And slightly different, we're not just looking at sort of data subject rights generally, we're looking at them more in an employment context. So although lots of you might have dealt with them in a customer role, with employees, there's sort of an extra layer of complexity. And that's where my colleague Gemma and her expertise can step in. So Gemma.
Thanks, Charlie. Yeah, I think if you all have a think about the types of data subject access requests you might normally deal with, which concern customer or marketing data, typically that information is quite structured, would not necessarily be mixed, and ultimately will be able to pull it together quite quickly, even though you might have a lot of it. I know that a few of my clients are able to capture that data within, a click of a button. Take a step away from that and think about what you as an employee do at your desk all day. You write emails. If you're anything like me, as well as my email address, each email will be littered with my opinions and my views. That will all be my data. There's the metadata on computer usage that Field Fish will be collecting. There will be CCTV logs. There's my calendar appointments, every automatic out of office reply. There are the documents that I am creating, memos, again, giving my views and opinions, my attendance records, my access to locations, well, the office rather. So all of that is in unstructured format. All of that, well, a lot of it, the emails in particular, are mixed with other people's data, third-party data. All of that makes handling employment data subject access requests really time-consuming and expensive. However, you still have to deal with it in a helpful and compliant manner. And if you don't, then you're ultimately going to cause yourself problems. Now, in probably, well, I have to say, in 100% of the cases that I've been involved with, employees or contractors, or basically anyone in a workplace context, will raise data subject access requests because they're aware of the time and expense that they're going to put you to, and they're using it as a leverage point, particularly with a view to reaching settlement. As I say, you still have to deal with it in a helpful and compliant manner. As Charlie said, we're not going to talk you through the law on this in particular, and I'm also going to avoid kind of tactics for I don't know, being sneaky with these things. What I want to give you is some tools to actually be able to deal with these data subject access requests in a helpful and compliant manner, so that if you are ever approached by a regulator, and I have to say a lot of people are getting kind of follow-up questions from regulators where data subject employees have got in touch and say, oh, actually, I don't think this has been handled correctly. So if you do ever receive one of those letters, you're in a position to show that you tried your best, that you've tried to comply in somewhat difficult circumstances. So Charlie, if we go to the next slide. So this is something, we receive this sort of thing quite a lot, or our clients receive them quite a lot. It's just an extract here, but as you can see, it's a letter that will set out the cause for concern in relation to an employee. And this kind of thing can come directly from an employee. It can come from an employee's representative, essentially setting out a list of complaints. It could be in the form of a grievance, it could be in the form of something more serious, or it could be, in the context of performance management, actually just a lesser dispute. And then immediately afterwards, you'll receive something that looks like this, or a longer version of it. We've just tried to keep things short.
Yeah, we should add that they're not always this blatant. Like someone might not say under Article 15 of the GDPR, but you get the gist of what kind of thing it might say in a letter.
Exactly. And so, you know, this was an example from a case that I'm still dealing with, actually, obviously completely anonymized and kind of added made up names. But if you have a look at the next slide there, Charlie, just pulling the key things out. So we've got the employment dispute, and the DSAR was sent on exactly the same day as the letter that we received from the employee solicitor. In fact, that the employment claim letter even alluded to the data subject access request and said at the end of it, if you want to make a sensible offer to us, then, you know, and to settle this and our data subject access request, then please let us know. So it's pretty forward in its kind of what it's seeking to achieve. So when you receive this sort of thing, I think the first thing to do will be to make an initial assessment of your next steps. And this is the thing that I try to help clients get finessed early on. First thing, as I pulled out, look at the date, work out how long you've got to respond. You've got 1 month to respond, either in full or to let them know that you're going to be making use of the extension. I should make sure that it's on people's radars at the moment that the ICO has recently changed its approach to the time limits. I don't know how many of you are aware, but the guidance used to say that time ran from the day after receipt of the data subject access request, and in August there was an update, and that's now changed to the day of receipt. So in this case, your first month would start from the 24th of June. The second point to start thinking about immediately is kind of, there are two conjoined points really. Firstly, strategy, and secondly, who's going to deal with it. I'll deal with the latter point first. In an ideal world, if you've got the setup, I really like to see the HR matter continue to be dealt with HR and in-house employment counsel or external counsel. It's a really good idea to try and separate out the data subject access requests, even though the employee will continue to try to draw them together. The reason they're trying to draw them together is either kind of misunderstanding of what the data subject access right actually involves, or simply to make your life difficult. If you look at this letter in front of us, this is a pretty standard comment. Please provide copies of all the documents that you process about our client. I think this is, as I say, a common misapprehension, not only by employees but also by employment lawyers, that the right is to documents. Don't forget that the right is to data. And if you can, that is why kind of separating out the process can be quite helpful in taking the heat out of this type of request. Next question. Do you have to do anything to identify the data subject? Remember that you're allowed to ask for information if you've got doubts about the identity. Now, if you're dealing with a current employee, for instance, someone who's going through a kind of hotly disputed performance management process, then you're going to know who they are. But what about if it's someone who's messaging from a personal email address? I don't think you should be shy about asking for further evidence of identity if you don't have that email address on record.
Is there something which we should be asking for, like as a set format of we need these documents to verify your ID, or is it just personal to float that business?
It is personal to that business. There was this really interesting article that I think our colleague Robert Fett circulated back to our team back in August, and it was an article from the BBC. And actually, your question, Charlie's made me wishing that I put an excerpt of it here. If anyone wants to find it, Google BBC, I think it was like Red Hat or something like this. But basically, this researcher sent out data subject access requests to something like 89 different companies, and he purported to be his partner with her consent. and he didn't create any documents, but what he did is he put in data subject access requests and waited to see what he got back, and it was, you know, something shockingly low, like 33% of those companies actually asked for a solid piece of proof of identity. Some didn't ask for anything and simply provided results. Some of them asked for things that were easily constructed or accepted something that was easily constructed. So whilst he didn't forge anything, he would say send the a photo of the front of an envelope. So there is no guidance about what you should accept or what you might ask for, but that, you know, think practically. You don't want to make life really difficult, but I think it's going to be quite I think you'd have to go quite far to be criticized for making life too difficult for people. You just need to make sure that you're providing information to the right person. Now, in this case in front of us, we didn't have so much a concern about the identity of the data subject, but rather the fact that it was coming from her lawyer. So we knew who the data subject was, but what we didn't have for certain was proof of authority to act in relation to the data subject, and importantly, confirmation that we were allowed to send copies of that data to her lawyer. So that's the point that we decided to pick up in our communication here. And if we look at this next slide, those 2 points about kind of separating out the processes and asking for confirmation, you can see. So firstly, on the left-hand side, you'll see that it's a letter from HR saying, right, we're dealing with your HR complaint. This is really serious. And it's also saying, we've asked someone else, we've asked a member of our compliance team to handle the data subject access request, and they're going to be in touch with you. Then if you look on the right-hand side, that is someone from the compliance team saying, please can you provide us with written confirmation from your client that you're allowed to receive the results of communications and results of the data subject access request. Next point. Where was I? Oh, yes, and it is another point I had on the strategy and how important it is to think about this at the outset. As I said, it's going to be time consuming and costly to deal with this. If you know that there is a grumbling, something that's grumbling towards litigation and that your company is likely to settle it, then the people handling the data subject access request really need to note this early on, because it's frankly a waste of time to spend the time, money and resources in dealing with it. If, on the other side of that, if this is going to go towards litigation, remember that there is a separate obligation of disclosure, and the ability that you have to only provide the personal data pursuant to a data subject access request does not apply in relation to disclosure, where, for instance, in the UK in particular, you have to disclose information or documents. It's all about documents that are relevant to the case, whether they help you or not. And you don't have the license to redact information if, for example, it contains third-party data. So say if you were in the unlucky situation where your date for, and this is quite a crude example, but your date for producing data subject access results coincided with your date for disclosure, then it would probably have been a waste of time to spend all the time redacting the documents that you would be disclosing as part of the disclosure. Am I making myself clear on that, Charlie? Do you think it's a little bit of a
yeah, don't spend all your time redacting something which you're going to have to produce anyway under disclosure when you can't give it a redacted document. So yeah, you're going to give them both the same document, one redacted, one not, and you're going to have wasted how many hours redacting those documents in the first place.
Exactly, and it's a really case specific point, and my point here is to emphasize how important it is. Whilst you want these things to be dealt with separately, there does need to be kind of some overarching consideration of where this matter is going to and how both prongs are dealing with it. More considerations for the initial assessment, and this actually goes to the stuff that I'd encourage you to try and think about before you end up in this situation, if possible. Do you understand the architecture of your systems? If not, can you find out quickly? And what I mean by this is, are you going to, how are you, if you receive one of these data subject access requests, how are you going to be able to search? Do you have to search against every single application separately? Can you perform one high level search, you know, somehow input someone's name and get a whole load of things that will include results from Word documents to calendar appointments to emails and the rest? It's really helpful, and I will explain why shortly. It's really helpful to be able to provide, to get a crude high-level number of the data set that you're working with as early as possible. And you're not going to be able to do this successfully if it's going to take, you know, 2-3 weeks for us to find out who in IT is able to help with this sort of thing. So if you're able to, it'd be helpful to have someone who's your go-to person who understands how the system works and how you'll be able to perform these searches.
I think that's a really key point. It's don't wait until you get a data subject access request to then figure out what your process is or who is going to be dealing with it. You need to know that as soon as that letter comes in, like Gemma said earlier, as soon as these example letters came in on the 24th of June, you need to have started doing something that day because your time is running from that day. And hopefully that person who can deal with it in, say, IT is fully aware of the data subject access procedure and what they're entitled to. It's very difficult to then start to train them up, and the first one they get be their training exercise.
I know, I think the biggest waste of time I encounter is kind of incredulous clients who don't, where I have to spend a bit of time sort of convincing them, yes, actually you do have to do this, and bringing to my next point about, is it possible to limit the scope? That's probably the kind of most frequent question I get. Without a doubt, scope is probably the thing that's going to make the biggest difference to you in dealing with a data subject access request. For example, what we've got here is someone asking for all of their data. So in cases like that, so there's Article 63, and that says that an employer, well, controller, but I'm going to call them the employer here, where an employer processes a large quantity of personal data, that employer can ask the employee to specify the information or processing activity to which the request relates. So that's potentially quite helpful. You're not asking them to narrow the scope. Essentially, you're asking them for help to help you find that data. And I think that is really helpful, even where you're dealing with a situation where the employee has actually already been quite kind of forthright in giving you search terms and dates, because you still will need some help to find data within those search results.
And also it helps to know, as a strategy point, as to what that employee is potentially looking for. So if you know what the sort of scope is or what exactly sort of documents or data they're looking for, it sort of does frame as well your strategy is to think, okay, they're looking for X, this might be for these 3 reasons, that kind of thing. It sort of does help with the wider context.
Yeah, I think that is completely right. I think the tweak to that is you will probably know, right? So in the context of someone who's going through performance management, you'll know that they're looking for a smoking gun email where someone says, we just need to get them out. You know what they're looking for, but still it's a helpful stage in this process to get them to focus your search. Exactly. Most, you know, if you think to the end of the process, you want to be able to show that you have done everything that you can, and you want to limit the opportunity that they have to criticize you for what you've done. So if we go to the next slide quickly. I like to send out this sort of letter pretty early on. If you see that in this case, it was sent on the 7th of July, so really quite shortly after the first result, the first correspondence. That first line that Charlie's just highlighted there, that's actually pretty much lifted from Article 12.3, where it says that you have to provide information about the action you have taken within 1 month. And what we say in this letter is that we have already conducted an initial search. This goes to the point that I made about doing an initial crude search. You know, even if it's just, you know, if it's Charlie who put in a data subject access request to Field Fisher, you know, even if someone has done a search of the system, just searching for Charlie, or Charlie Guile,
Yeah.
you know, and that results in, I don't know, 32 gigs of data created in just 2 months, which is probably
about right.
you know, that is going to be helpful for this correspondence. And the reason it's helpful, firstly, it shows that you've done something. Technically, you've also complied with Article 12.3, although I wouldn't want anyone to try and argue that point with the regulator. But it also adds to this whole kind of pack of documents and pack of correspondence that you are able to show that you were trying your very best to be helpful in this search. So you conducted an initial search, which has produced this huge amount of data, and that you need their help to locate their personal data within that set. Because although you've got this huge pack of documents, that doesn't mean all of it constitutes their data. For instance, they will have there'll be emails to the whole company in there that they will just have been blind copied on, and the only data might be their email address. For example, if it's all about training updates or IT updates or whatever. So this sort of letter is really, really helpful. So what I go in to do in this letter is to ask them for search terms. There are a couple of different ways of doing this, and it really depends on the case in question. So one thing that you could do is provide them with search terms and ask them, you could say, oh, we're just going to proceed with these and not give them an opportunity to come back to you with extra ones. You could do the same thing, but provide them with the opportunity to add and add comments, or you can ask them to provide them. The approach you adopt really depends on the case in question. The majority of the time I take that last option, which is to ask them to provide them. And that's because I'm typically acting on quite contentious matters, and anything that I can do to show that actually I've put it in their hands is helpful to the overall strategy. But similarly, it could be that if you just want to get on with the search and you don't want to be waiting for the data subject to get back to you, actually providing them with the search terms and saying, unless we hear back from you, we're going to proceed on this basis.
Yeah, that was going to lead into my question. So what if they just don't bother giving you search terms? So you give them the opportunity, you say, search terms are really helpful for us to narrow this down, and they either refuse or they just don't reply. Are you still, during that time, having to deal with the data subject access request?
I think that's part of the reason why I like to put that first line in there about we're writing to provide you with information about the action we've taken, because we've taken some action and we put it back into their search terms, and then tying it back to our recital 63, that we're entitled to ask for more information. You know, from my perspective, I think we've got a fighting chance in saying that actually time is stopped then. However, at the same time, and it's a slight extension to your question, don't forget that you have the right to take an additional 2 months in cases of complex requests. If you want to take advantage of that 2-month extension, then what you need to do is tell them within the first month. So that's the other purpose of this letter. The Article 12.3 says that you have to explain why it's complex. So this example here would probably not be sufficient just to say it's complex. I haven't seen the point argued yet, but I think it's, you know, you could point to either the size of the data set, or you could say, you know, actually the majority of this is going to be mixed data, which is going to require, you know, a human to review it. Therefore, we're going to need to make time of the extended time period. I think any of those options or all of them would be fine. Some thorny issues to kind of bear in mind. We've mentioned about how you know, the architecture of your system and how you might be able to search for things. Also think about, you know, when you're getting that that straight in advance, think about whether there's anything you can do when you're searching to kind of limit the search at that early stage. For instance, can you exclude certain things? Can you exclude out of office replies? Can you exclude company-wide emails or calendar acceptances or those images at the end of emails? Because that's one of the most annoying things when we will typically get a kind of access to a platform to review the data set and redact them. You know, you'll have these separate image files at the end that that just take time to load and time to kind of remove from the data set. Essentially, anything you can do at the earliest stages will help you. If you can't do it at that early stage, then there are ways to do it depending on the platforms that you use to redact the documents. I haven't got time to talk about the platforms that you might use in the actual kind of redaction exercise this session, but it's something for you to have a think about. You know, if you are kind of vetting vendors, is like, how user friendly is it? How quickly can you run through documents, and how quickly can you exclude huge swathes of documents? What else is on there? Oh, the redaction and extraction. What I mean by this is, most people jump to the conclusion that what people are going to get in this context is you know, a massive wedge of documents that have been heavily redacted so that only the personal data is left. Getting to that stage is the most time-consuming part of this process, and it's where all the fees will rack up to. If you're in the context of some messy litigation, I wouldn't underestimate how annoying it is to data subject to receive that information. Yes, it's what they're entitled to. They're not entitled to a document. They're entitled to the data after all. But particularly if you're dealing with a litigant in person, it's going to be incredibly, it's gonna anger them. So it's worth thinking about extraction. When I talk about extraction, think about the fact of lifting out, looking at the document, identifying the personal data from the document, and putting that information into, for instance, a table. It's what some of our clients do in relation to customer data. So you'll have a table that lists either the date or the date range, the type of document, and then we'll literally lift in what the personal data is. And if it's you know, just their name or their email address, and then easy. Sometimes it might be, you know, you wouldn't necessarily, it would depend on the case whether you hand this over, but say if it was an email that I had sent about Charlie's performance,
all great,
to Mark Webber, for instance, and I was saying, oh, I think she's done a terrible job today, you know, and I had decided that that's going to be disclosable, I would extract that sentence. Just have a think about that. It takes about the same sort of time as redaction, but could be a better approach depending on the case you're looking at.
And I would also say, just on the redaction, just be really careful what, I know Gemma sort of alluded to sort of what providers and things you're using, but just be really careful, because there are other software where you, or just different computers where you open a redacted document and those redactions do disappear and everything can still be seen. So just be making sure, if you choose to redact documents, you have actually redacted them properly and remove sort of any metadata underneath that, so they cannot, that redaction can't be reversed.
Then a quick word, we haven't got time to deal with it in detail. We should have said at the beginning, I'm trying really hard to keep this to 35 minutes to keep it short and snappy so you can get back to your days. But third-party data, you don't have, you only, so there's a clash of rights here, obviously. You know, it would undermine this legislation. The whole thrust of like the data protection legislation ultimately is control of your personal data and privacy. If actually someone could override that by simply making a data subject access request, it wouldn't make any sense. So you do not have to hand over third-party data unless A, the third party consents, or B, it's reasonable to hand it over in all the circumstances. The ICO, in relation to the old legislation, had some useful pointers about the cases, the situations in which it would be reasonable to disclose without consent. And the employment code in particular gave some useful examples, like managers, or where there's no expectation of confidentiality and things like that. The key is you have to make a decision at the beginning of the process, the approach you're going to take. Are you going to disclose nothing except a manager's view? What you don't want to say is actually, we're okay with disclosing third-party opinions, particularly whether managers, and then you get to the end of the redaction process and find some shocker that you wouldn't normally have to disclose. And you know, this is where these employment matters become quite tricky. I personally take quite a stringent view to third-party data, and it's actually the approach I take, actually, to say it properly, it's not taking a stringent view to third-party data, it's taking a stringent view to the right. The right is access to your own data. So have a look at that guidance if you can. It's still relevant to this information. And the last point on that slide was privilege. And again, particularly where there are emails from in-house counsel, make sure that the searches that you do at the beginning are kind of picking up their names as documents to be excluded. Yes, there's a bit of a grey area about whether, particularly in the UK, whether advice from in-house counsel is privileged if it's commercial advice. But at least we don't want anything to slip through the net without at least having considered it. Again, this isn't an extract from the type of letter you might want to be sending with the results. You'll see that it provides access to the information and how they're going to access that information.
So, and on that point, yeah, it's one of these, there's not a specific obligation or sort of a specific rule to say how you need to provide that information, but don't let this be the sort of part where you sort of everything, all your compliance measures unravel. You should still be sort of ensuring you have appropriate security measures in place. So for this example, we've given them access through a link, and we're going to give them a password under cover of a separate email to make sure it's not all together. And as far as possible, make sure that we've applied some sort of security measures. There's nothing worse than if you've gone through all this process to make sure that you've found all the data and then suddenly you just give it all to them and you've not checked that it's all secure. So just be careful on that part.
That's exactly right. And then on the next heading, search parameters, again, there's no obligation to say, this isn't like the accompanying information that it says in Article 15 that you have to provide. However, remember, you've got a prevailing duty of transparency to be willing to provide information about what you've done. You could, if you wanted to, hold that back and wait till the individual challenges the quality of the search that you've done for their data. But I think that's inefficient. The fact is, as you've gone along, you should have been keeping records of what you've been doing, how you've been searching. And this is the point where you set it out. For instance, if you use search terms, well, if you did an initial search like we suggested, and it yielded that huge 32 gigs of data in relation to Charlie, then you should say that, and you should explain how you then began to narrow it down, how you applied potentially group A search terms and group B search terms to really focus your results on the data that they are looking for.
And I think as well on that, like giving them the information up front, like you said, because otherwise you seem to appear evasive. So they want to ask more questions or try and dig a little bit more to say, oh, actually, if they start asking questions and things start to come undone, there's more room there, sort of more wiggle room for them to find out more information.
Exactly. Then the next heading now, the withheld information. I had this slight panic attack yesterday because under the old Data Protection Act in the UK, it listed all the things that you don't have to provide information on. So there's confidential information about negotiations, management forecasting, privileged information, and it explicitly said you don't have to, if you're seeking to rely on any of these exemptions, you have to explain why. And I had this moment where I couldn't find that in the new legislation. I kind of went running around to Charlie's room going, Charlie, where is this? I've been putting this in all my letters. It's not in the GDPR, although come back to the obligation on transparency. If you are holding back information, then I say it goes to that point. But it is there actually in the new Data Protection Act in the UK. So it's quite a UK-centric point. If you are dealing with a data subject access request in a different jurisdiction, then it's worth you double checking, firstly, if it's there, and secondly, whether you want to give that information. And then lastly, we've got the accompanying information. That's the information that Article 15 specifies that you have to set out when you provide the results. I think I've said before on one or other of these webinars, that information should have been set out already in your privacy notice. So the approach I like to take is to summarize that information, like we process your information in connection with your employment. For more information, please refer to the privacy notice, a copy of which we've attached with this response. That's the approach that I like to take. If you're with a company who perhaps is not quite so proud of your privacy notice at the moment, then maybe you'd want to be a little bit more expansive. So yeah, next slide. So this is just to summarise. We haven't gone too badly on timing, Charlie, for once.
1 minute.
I hope I haven't been speaking too quickly, but this slide should just summarise the things that you need to be thinking about. They're key steps, key considerations. Have in your minds that if you get one of these things in, as I say, that someone else should deal with it. That will just take out the heat, and it'll avoid people falling into this trap of thinking that you're going to give documents. You're dealing with a data subject access request, not disclosure here, although there is an overlap in these cases. Make sure that you know who are your go-to people in IT and compliance and who can help you deal with it. And make sure you've got those initial assessments about timing, strategy and communication sorted early on. And I think that is it.
It is, yeah. So we sort of managed to wrap that up.
Faceless Charlie on this slide.
This is because the original speaker changed very last minute, so I couldn't get my photo on there. But we've managed to do that in 35 minutes, so that's great. As with all our other webinars, they'll be uploaded to our YouTube channel later on today, if not tomorrow. And there's also a link on the slides for all of our blog posts, so if anyone's interested to follow that. And we have another webinar on the 12th of November, which is going to be on accountability under the GDPR, DPIA, triggers, practical tips, and best practice. There's an invite going out later this week, hopefully. If you want to be added to the list, please just email us, but alternatively, you can get the link through our website as well. But that's great. Thank you for listening.
Bye, everyone.